This segment is brought to you in part by the Canadian Historical Arms Society, owners of the Judicially Range, the premier recreational sport and training facility in Western Canada. See us online at historical-arms.com.
The Quiet Professional, a podcast about law enforcement, security, justice, and politics. We are digging deeper on the issues and going where the information takes us with access to experts and authorities. Welcome to The Quiet Professional. Hey everybody, welcome back to The Quiet Professional. Today, we're going to be talking about law enforcement news, from AI to training, and we might get into some pieces on qualified immunity, a little bit of a continuation from the prior discussion with our guest. And before we get into that, I'm going to welcome my co-host, John Simpson, and say thank you for getting our guest back on the show. So thank you.
Oh, very welcome.
And as I did before, we're going to reference our guest as Dr. Peters, but his name is Dr. John G. Peters, just so we don't confuse the two in here. And if you didn't see the previous show, Dr. Peters is the president and chief learning officer at the Institute for the Prevention of In-Custody Deaths, Incorporated. He himself is also a former police administrator, officer, and deputy sheriff. So welcome, Dr. Peters.
Well, thank you, Nathan. Good to be back.
As I was saying, we had a really good discussion last time, and we got into so many topics. I know there's good feedback on it. People learned a lot. So I'm happy to get you in here. And I really do appreciate all the work that you're doing because, as I said there in the bio, you've held a few positions, just to name a few, but you're still going. And everything I think we get into today is going to be very relevant to what people are experiencing now, but also what's kind of coming in the future. One of the spots maybe to start with, though, is, you run some training conferences, and I just wanted to kind of start with like what you've been up to lately, any new developments, and anything that people should really be paying attention to.
Well, our latest big program was expert witness training that we ran in Las Vegas. It was a live program. It was 4.5 days long. And we pretty much covered everything that a new expert witness needs to know. And then we also covered some topics that most people aren't aware of. And many of those focused on the use of artificial intelligence and how lawyers, not officers, but how lawyers are using AI to dissect police reports and police expert reports. And we also covered in that program some of the real forward cutting edge things that are out there, such as officers relying on artificial intelligence to create their first draft reports or maybe their final reports. And some of the problems with that we covered in rather great detail that, don't rely on it. There's some problems. And in California, there is a statute that says if you use artificial intelligence to create your report, you must save all drafts of that report.
Okay.
And there are some artificial intelligence platforms that don't save the drafts. So a question that was addressed by one of our presenters who was an attorney is, how do you comply with the California law if the platform you're using doesn't save all your drafts? And then, of course, we covered a lot of contemporary issues that experts needed to know about, the latest in prone restraint, some of the things that officers can do, and some of the new techniques that are coming out, such as the SAFER app from the Gracie University, being adopted quite often around the United States, at least. And here at the Institute, we are doing a research study. Dr. Dal Ross and myself are just beginning to analyze. We have 97 field reports that just came in from around the United States from 13 different departments on the effectiveness of the SAFER app. And we're looking at it from an application viewpoint, a safety viewpoint, injury viewpoint, and obviously the effectiveness side of it.
Is this something that's built into their use of force, or they're just, if somebody happens to do it on the street, then they kind of come back with some experience and they can talk about it.
Having talked to Renner Gracie about this, who's the lead instructor on it, when they go out to train a police department, part of their licensing agreement is the department must send them reports, incident reports, of the use of the safe wrap. So they just got into Baltimore City Police Department in Baltimore, Maryland. So we're expecting quite a few reports from there. But the agencies that have been using it, they're starting to send in those reports. Now, obviously, there's not going to be a lot of reporting because it's used in a pretty specialized way. But the technique itself, and I've looked at it, I've seen it demonstrated, I've talked to people who've applied it. The technique itself doesn't put anybody in a prone position. It puts them in kind of a lateral position on their side, and two people can hold them. They can't escape. And then they move from there into handcuffing in the lateral position. So we never put anybody in the prone position, and that eliminates a plaintiff from saying, hey, you put them face down causes positional asphyxia in and of itself, which we know isn't true, but plaintiffs will still argue that, and then it's up to the officers and the agency to prove that it doesn't. So from what we've seen so far, it's been very effective. And I was on a panel at the California Force Instructors Association last year, and Renner was on that panel, Renner Gracie, and he was describing it, and I leaned over to him and said, hey, we do research in the Institute every year, and we allocate so much of our proceeds to do that. We'd be willing to do this research for you at no cost. And he jumped at it. So we're getting the field reports to analyze. And as I said, we've got, it's either 97 or 98.
You get the ones from Baltimore?
We haven't gotten any from Baltimore yet because they just started the training program, but we expect by probably the middle of June to have at least one or two. And Dr. Ross and I are going to analyze everything and present that analysis at the California Force Instructors Association conference in August in Southern California. We're going to continue that research, and we've already told the Gracies, look, as these reports come in, keep sending them to us. Obviously, we have to have a cutoff point to get everything analyzed and statistically put together for the CalFIA conference in Southern California, but we want to continue this, and our minimum number of field reports is 100. Because if we have a sample size of 100, we're statistically pretty guaranteed that'll be a good representation of what's going on anywhere that the technique's being used. But if we can eventually get that up to 500 or 1,000, that would be really, really good. So we've got that project underway at the Institute, and also another project where we're looking at the efficacy of electronic gloves. And we have quite a few field reports there as well, and we'll be working on that over the summer and getting that research published.
Okay. And just on talking about this technique so far, though, so this is like a physical a way to physically restrain somebody. It's not a device or anything. Just to clarify for people, it's like a jujitsu move, for lack of a better term.
Well, you're spot on, because the Gracies have the jiu-jitsu market for the most part, and it is a technique, a physical technique. You're quite right. It's not a device. It's nothing that you apply to people like a belt or some kind of a suit or anything like that. It's a physical technique. It's very easy to learn. It's very easy to apply. We've seen body-worn camera footage where it's applied in a field. Two officers come in and just control the person.
Yeah.
And the person really can't break free the way they have this designed. And the technique itself was developed for mental health hospitals.
Oh, really?
That's its origin. So as you well know, and your listeners know, mental health hospitals have to have techniques that are very safe. And these guys developed it and then saw this opportunity to transfer it over to law enforcement. And so far, it's working very, very well. And they're getting new departments signing up every day. So we're excited about looking at the research. And Gracie and his team are very keen on understanding that they need medical research done. They also need other scientific research done. We're not looking at the medical implications of breathing or anything like that. They've already had that looked at. But Dr. Gary Vilk, who is professor emeritus at San Diego School of Medicine, he's done an extensive video on it, explaining the risk, and basically it's very, very limited. So you could go to the Gracie website and actually take a look at that on SafeWrap, or just Google SafeWrap technique, and it'll pop it up and you can listen to it.
I encourage people to do that. And actually, I gotta say, I really love the idea of, like, when you have people that go outside of the profession and look elsewhere for solutions. I mean, we can learn a lot from other people. So that's always good. And that people are kind of paying attention to this and trying to incorporate some different things, because we certainly don't have all the answers just within law enforcement. So we need the help of others.
Oh, you're absolutely right. And our mission at the Institute is to help people. We want to save lives and we want to save careers. And this is a way we can do that, by providing this type of research. We're also working with two other individuals who are working on police equipment that is really cutting edge. One person is working on a handcuff that will monitor vital functions.
Oh, really?
Yeah.
It'd be like a Apple smartwatch kind
of. Similar. The electronics on it, I think, are very similar. We've seen the prototype and it seems to work well. And then there's another group on the West Coast of the United States that's working on what I'll just describe as a Band-Aid. That's what it looks like. It's like a Band-Aid that you put on the forehead, and it monitors the vital signs and has a transponder that sends it to your phone.
Oh, wow.
So again, we're on the cutting edge of some of these things that I think are really going to minimize liability for law enforcement officers. And both of these devices are pending FDA approval. One of them, it looks like it's going to get it. Well, actually, both of them look like they're going to get it, but one's really, really close, which raises a whole other set of issues for the manufacturers of these devices. But they're really, really good. And, I think it's just a matter of months until they hit the market. So,
when you said the handcuffs part, though, two things came to mind for me. Was one, how many pairs of handcuffs I've lost in my career. Either someone else steals them from me, not a bad guy, but like another cop, or they get left on like the hood of your car or the top of your car, or where, you put them down somewhere and then you drive and they like fall off. So as long as they can survive that, or maybe it's like iPhone, I have Find My Handcuffs kind of built into it. The other thing is, we had an arrest recently where person that was arrested was covered in a lot of fecal matter. So as long as they can withstand all those extremes, I think they might have a pretty interesting market.
Well, the person who's developing the handcuff that monitors vital signs is a active federal law enforcement employee here in the United States. So he's well accustomed to all the
scenarios,
variables that you just described. So I'm sure they're going to look into that. Having another officer take your cuffs, I don't think they're going to have a widget to figure that one out, but it may not do them any good, because you'd have to have your own phone and dial it in. And I'm sure it's going to be pretty specific, but we all know our colleagues, new toys come on the block. You got to have one.
Yeah. I'm just wondering where maybe to take this conversation, because there's a few things you mentioned. Obviously, AI and policing, this is going to be huge. talking about the report writing and stuff. But maybe before we get to that, because I think this is going to be the biggest part of the biggest bulk of the discussion. John, you also want to bring this up, but just maybe jumping back into this qualified immunity discussion. It's a little bit of a continuation from what we talked about in the last podcast. But I don't want to say the last time we had you on there, Dr. Peters, might have been April of last year. And then the Supreme Court came out with a decision in May or June discussing qualified immunity, how it applies, the test or the standard that's going to be used. Did you guys want to start talking about that a little bit?
Sure. You have any specific questions, John?
Just that I understood that there was a and basically what inspired this was I'm of course I'm on your mailing list, and I saw that you were sending out an email for a seminar that it wasn't being conducted by the IPICD, but it was also is being boosted by you. And it was a case of because of recent court decisions, which most cops on the street or even administrators can't keep up on. There'd been a number of changes in the laws concerning qualified immunity. And I just wondered if you could address that, even briefly with, we went from this to this, and this is the current operating environment.
Yeah, I think the latest case on this is the Zorn case. It just came down a few weeks ago. And totally transparent. I'm not a lawyer, so I'm not giving any legal advice. And the reason for that is I'm not licensed anywhere because I'm not a lawyer. So it makes sense. But the Zorn case really came down and really kind of defined qualified immunity. And qualified immunity here in the United States is clearly established law. When you're looking at stuff, officers are entitled to qualified immunity if the law is not clearly established. So if there's a question in a federal circuit and the law is not clear and the officer may not have known about it, that officer is generally entitled to qualified immunity. So when the Zorn decision came down a few weeks ago, right behind it came the Scott decision. And that decision, that case started in Las Vegas with the Las Vegas Metropolitan Police Department, where they answered a call about a person who was experiencing a mental illness episode. And they went and they talked to the guy, and he was holding some items that appeared to be weapons, and they asked him to put it down, and he did. Then they went to do a pat down to make sure he was safe, and that's where things started to go sideways. So they put him in a prone position, and they put some weight on his back, a knee, to hold him in place. And it's estimated that that knee might have been on the back for, let's say, a minute or so, and he expired. Well, that case went to the Ninth Circuit Court of Appeals, and they made a ruling that said putting a knee on the back for that period of time is deadly force. Pure and simple. And they referenced a case called Drummond that had been decided a few years prior, and they kind of made a big deal out of this. Now, California has some separate criminal statutes, one of which says a law enforcement agency shall not authorize any technique that may lead to positional asphyxia. So this is kind of an interwoven situation here where we now have the Ninth Circuit saying a knee on the back for a minute period of time is deadly force. Then you have the California statute that can hold officers criminally liable and agencies, municipalities as well, for allowing these techniques. So with that as a backdrop, the Ninth Circuit decided that decision way before the Zorn case came down a few weeks ago. And then the Supreme Court took the Scott case and they granted certiorari. And at the same time, they remanded Scott back to the Ninth Circuit and said, you may want to relook at this given our ruling in Zorn. So that's almost unheard of, that the U.S. Supreme Court would accept a case and remand it on the same day. So what most of our advisors are telling us, our legal advisors, is that basically with the Zorn case, and there's a couple elements now for qualified immunity. Number one, there must be clearly established law. It must be clearly established that what the officer did was prohibited. Part two of that is that the officer knew about it. And that's where right now it's really sticky, because the Supreme Court didn't address that. Nobody has defined the time frame the officer needed to know about it. So we've all been in the business. We know how things work. A court decision comes down, let's say Friday afternoon at 4:00. Well, the training officer knows about it, maybe, or the chief knows about it, maybe, or maybe the municipal attorney knows about it, maybe. Well, how long does it take to digest that case, understand that case, and get the word out to everybody so they're trained about it? And that's the big dark hole right now.
We see the same up here. So we have a team of legal advisors, and like when a decision comes out, it's got to go down to them first, and then they look at, okay, this is a decision. How are we going to implement this given our policy and like our set of standards, and what does this mean for us in our city? Because it could be different than the next city, right? So, it could take weeks, or longer.
So as you correctly noted, Nathan, this decision could sit on multiple desks being interpreted, analyzed, written, rewritten, comparing things to policy before it gets out. So what does an officer do during that time where the decision's been made, and a week later he or she does something that, let's say, contradicts that decision?
Well, maybe if I could jump in on that, I think the confusion about a lot of that comes in when, as you're saying, it's coming back down this chain of people. I mean, they got their own interpretations. You could go in a room of 10 lawyers, you're going to get 13 opinions, right? Like the old saying. So they can tell you how to do something. And we've run into this even up here in Canada, like where your legal advisors tell you you're good to do this. Then you go and do it as they stated. And now you're in trouble. You're still in trouble. And even to a point where maybe the police service could look at you and say, like, well, you didn't do that correctly. It's like, but that was your training. So where's the service take responsibility? What falls on the individual officer as well?
Yeah, and those are good questions, because the officer's relying on the training. The training is authorized by the department. So the agency really has endorsed the training.
Yep.
And if you don't stand behind it, and I think Minneapolis was a great example of this, they train people to put knees on the neck.
Yeah.
And then at the end of the day, they basically said, King's X, we were only kidding about that. You wind up intentionally or unintentionally throwing your people under the bus. And it takes a while to sort out all this stuff. I mean, you're right. 10 lawyers will issue 13 opinions. Well, what's the officer supposed to do? And even worse, here in the United States with our various federal district courts, you can have a decision in the Ninth Circuit that's not followed by the First Circuit, that's not followed by the Fifth Circuit, but the Sixth Circuit might. So depending where you are in the country, there's different standards, and ultimately it will go to the Supreme Court and it makes a decision. But in every one of those cases, they're using hindsight
Yeah, totally.
to make the evaluation, where the officers aren't allowed to use hindsight when they're making their decisions. So it's crazy.
And even in our last discussion, because I downloaded this here, it was just talking about the Barnes versus Felix case. So I'm just kind of
Right.
looking at it on the same screen. Even in there, they were talking about the moment of threat doctrine versus the totality of the circumstances analysis.
Right.
And I thought, the way they describe it in this was from congress.gov. Hoping it's correct. But the way they explained it was just kind of interesting. And it basically came down to, like, the way I conceptualized it in my head is the moment of threat is like you just get the Instagram clip and that's all you get for context. And they're like, make your decision. Are you shoot, don't shoot based on this 5-second clip? Whereas once it got to the Supreme Court in this decision, they talk about the totality of the circumstances, which I think makes more sense. Then they're like, no, everything that came before that, all that context still matters. It's still held in the officer's head when they're making their split-second decision to use force or not. Because what I think a lot of people also forget is use of force is a continuum. It goes up and down. Like, I can have my pistol out and then the person de-escalates. Maybe I transition to a taser or hands, going hands on. But to like throw all that out before, you're missing out a lot. And then it just essentially comes down to, like, how I was kind of thinking of it as, just that 5-second clip, and you can make all your opinions off that, and that's really dangerous, essentially.
The analogy I use is a roll of film.
Hmm.
And for a lot of people today, they may not know what film is, but whether you go back to, the days of film, and film starting to come back a little bit in cameras today, it's the last frame. It's the last picture on that roll of film.
Mm-hmm.
And that's the moment of threat. What we still don't quite know, and it can be problematic, when you talk about totality of the circumstances, where does that begin? Does that begin with the background investigation of the officer as an applicant for the job? Does that include the police academy training? Does that include all your in-service training? Does that include all your lesson plans? Totality of circumstances, according to some of the attorneys we've talked to, does go back all the way to hiring.
I think I've been asked like about training experience when I go to court,
Sure.
especially if it ends up being like a higher use of force. You go like, okay, what's your department policy on this? I mean, they kind of ask that with a lot of things. Like, we are really starting to get into the body worn video, and they're asking about that. But I think that kind of comes up in a lot of things right now. It's just, where's that line? I could be up there for years, essentially, if they want to ask about your whole life.
Oh yeah, and the real hurdle in some of these cases is, if you have in your lesson plan, don't put people face down because they can die from positional asphyxia. That's in a lesson plan. That may be in a policy. That's part of the totality of the circumstances. You have an officer out in the field who has to put somebody in the prone position momentarily. And let's say the person has a sudden cardiac arrest. Did you violate policy? Did you violate training? Because that's not part of the totality of the circumstances. You were trained not to do that. But in this situation, maybe they had to. The law may not be clear, or the law may be clear, but now you've got this issue of, did you violate policy or training?
Yeah.
And that muddies the waters even more. So it in some cases, it's really helped us, but I think there's still guidance needed from the courts on a couple of these issues.
Yeah, no, I really appreciate the perspective that you're kind of offering. I think it sounds like, at least on the U.S. side, with the Supreme Court, they've kind of gone toward the totality of circumstances. That's their decision.
Yeah, that is, and I think overall it helps. I don't think it necessarily hurts law enforcement. It's also consistent with some of the other laws in the country. One of the difficulties we have here in the States is we do not have a national police standard or a national police force concept. So every department has its own policies. Every department has its own way of doing training. Every department has its own way of doing whatever it wants, basically. But you still have to follow the law. So I think the Supreme Court decision in Zorn and remanding the Scott case back for reconsideration, I think is an attempt to kind of get standards across the country that people understand. But quite frankly, here in the United States, there's a lot of attorneys who don't understand qualified immunity. And then you have a state like Colorado that has eliminated qualified immunity at the state level. Now, it's still in place at the federal level. But if you sue officers at the state level, qualified immunity is gone.
What's the difference there? And that's something that I saw in some of the readings I was doing preparation for this podcast, but I don't quite understand. Like, you guys can do things at a state level. If it doesn't work there, you can jump to a federal level. And
yeah, the federal laws apply across the country. For instance, here in the United States, if an officer gets sued under our Title 42, 1983 Civil Rights Act, federal law takes precedent. So you have federal law decisions. Most of those are on constitutional issues. But then you have each individual state has its own state statute and statutes, and some adopt most of the Federal Civil Rights Act and some don't. So in effect, you could win your case at the federal level and lose that same case in state court because of the way the state court interprets things and has its own rulings. So as a general rule here in the United States, most attorneys want to remove any litigation to federal court because it's uniform across the country. So if a lawyer takes the bar exam here in the United States, he or she can practice in federal court anywhere in the country. But at the state level, they're only authorized to practice in that state under those state laws. So it can be kind of cumbersome because you have federal laws, then you have Supreme Court decisions that apply to everybody, regardless. You have state laws, then you may have municipal laws and resolutions and ordinances, and it gets to be kind of a nightmare. So what may happen, let's say, hypothetically, in a case where somebody proned somebody out and they were wildly out of control and the officers proned them out, they put a knee in the back, they handcuff the person dies. In federal court, there may not be a problem at the end of the day. The lawyers would argue, look, the guy has sudden cardiac arrest. We're not responsible for it. There's nothing that prohibits it. So we're good to go. Mm-hmm. At the state level, they may argue negligence. The plaintiff may argue negligence and say, look, this officer violated policy. This officer violated training. Therefore, he or she should be held liable for that violation. And they could be, even though they won at the federal level.
Okay, but the federal level, they were looking more at the constitutional side.
Constitutional only. There's no
policy.
Yeah, there's no negligence in a 1983 action.
Okay.
Yeah, it's denial of civil rights.
Yeah.
Yeah. So, and another thing that can kind of complicate things in the United States, we are a legal system based on civil rights, not human rights. And when you leave the United States, there's a lot of countries that are based everything on human rights, including the United Nations. So a lot of the United Nations opinions and things focus on human rights, which is much broader than civil rights. So it's a complex spider web.
Yeah, man, I don't envy anyone's job trying to figure all that stuff out. But you know what? Maybe we'll kind of jump a little bit into the AI discussion because I want to spend quite a bit of time on this. This is going to be something that's really affects policing, good and bad. I think we get into both. You've got quite a bit of experience on this, Dr. Peters, and you just did a course. We were kind of saying before or a program on this. Do you want to talk a little bit about, maybe just start generally, like what's coming for law enforcement, the good, the bad, like some of the stuff that you've been exposed to recently?
Well, you're right. There's hurdles in front of us, and there's good news as well. I've taken 30 separate courses on artificial intelligence, one of them being from Massachusetts Institute of Technology, MIT Sloan School, and CSAIL. And I've taken another one from the University of Las Vegas on agentics. And most recently, just a couple of weeks ago, I completed a 6-month program in generative artificial intelligence from Johns Hopkins University, Whiting School of Engineering. And none of those programs specifically looked at law enforcement, because law enforcement is a very small piece of the pie. But from our perspective, law enforcement and the use of artificial intelligence is huge, because we have robots, we have agents, we have drones. We have all sorts of things that we're now using in law enforcement that are based on artificial intelligence. Electric cars are artificial intelligence. Siri and Alexa in your homes is a low-grade artificial intelligence. Using your GPS to find an address, artificial intelligence. And we have one agency here in the United States where GPS took them to the wrong address, and it cost the municipality $400,000 because they had a no-knock warrant, broke the door down, and got inside and went, oops, wrong place. So the recurring theme in any artificial intelligence, and as we get into this, I'll try to remind your listeners, but they really need to understand: verify, verify, verify. You've got to verify the information.
Maybe on that, I would say, and this kind of stems from what we were saying before we fired this up, the speed with which AI just, it helps you tremendously. So it gives you the speed, but kind of what you make up for in that time, you definitely need to spend on, like you're saying, the verifying side, the corroborating side, reading your material, making sure it says what you need it to say. Addresses are a good one.
Yeah, absolutely. And body-worn cameras, since you mentioned that that's starting to be adopted widely in Canada. Body-worn camera, a lot of people think is the end-all. It got everything. No, it didn't.
Mm-hmm.
It didn't get everything. And some of the things body-worn camera doesn't get, it doesn't get smell.
Yeah.
When you walk up to a car and you smell something, or you go into a house and you smell something, or you're out in a field and you smell something, body-worn camera doesn't pick that up. Body-worn camera doesn't pick up tension in the body. If you're holding somebody, body-worn camera is not going to pick up that person tensing muscles. Not going to pick up necessarily the interpretation of facial expressions. Not going to pick up that gut feeling that officers have. And if body-worn camera is pointing north and your concern is looking east, it's not going to pick that up.
Yeah.
And then you have the lenses of the camera, and most of them are sort of fisheye lenses. It's going to distort things. And a lot of times, and we've seen this a lot in disciplinary hearings, Internal Affairs is relying on the body-worn camera footage that shows this guy, the officer, rapidly attacking this person. But when you download that and play it the way it should be played, that didn't happen. Body-worn camera also many times compresses the frame rate. So it may not show things that actually are there. The North Charleston shooting in South Carolina a couple of years ago, the officer said, the guy grabbed my taser. We struggled over the taser. Well, the chief looked at the incident replay of the camera and went on the media and said, that camera doesn't show that. The footage doesn't show it. But when they took it to a forensic analyst, video analyst, there it was. So we have to be very, very careful not to engage in knee-jerk reactions when we see things, And also, we really need to pay attention to what did that camera capture versus what I, the officer, experienced at the scene. And this puts the spotlight on first line supervisors.
Yeah.
Because first line supervisors usually approve that officer's incident report. And it's no more just simply reading it and initialing it. You've really got to know that incident report captured what really took place, because you're going to live with that report forever.
Well, even without the cameras, that's something I've had to deal with. Like, I'm a sergeant of a team right now. And when you go back and you look at some of the reports and you're compared to like what someone tells you on scene, it's not that it's different. It's just like they forget to put some stuff in, or lacking in detail where you're like, well, you probably want this because it actually explains more. It explains more about what's going on. And, but I'll say, like, even when you get to court, you get different questions from defense, you get different questions from Crown. And then the next time you go out and do something, you're like, well, they said I should have done this or shouldn't have done this. So now I'm doing that. And then now go to court on that matter. And then they give you some opposite questions. And it just, like, it keeps
Right.
changing it down the road. But I think, like, especially with the cameras, and because this is kind of the biggest thing I'd say we have right now. Next, that thing that's coming is like report writing and some things to kind of speed up the processes for us. But right now, cameras are a big piece of it, and definitely the review is important. I hadn't heard about the compression piece specifically. I think that is very critical. That's interesting to know. But what's funny about that is, like, that's even something that 10, 11 years ago when I started with this police service I'm at with now, and we had to go get video for homicides. I was in a pre-hire position with homicide unit, and we would go out, get cameras from whatever, all the buildings around where something happened. They would actually make you watch it, the whole video. But then when you transfer it to a USB or a DVD or however you're getting it to disclosure, they want you to check it again.
Right.
And say the transferred files are the exact same. Like, I watched this video and confirmed second by second that these are the frames that show up. Especially because some videos only motion activated and different things. It glitches all the time. So they want you to watch it. When you transferred that specific little file, did it cut anything off? Did it leave one little byte of data behind that, shows this person's guilty or innocent?
Yeah, you're absolutely right. And there's another important concept that's really starting to be talked about, and it's called the God's eye fallacy. I just published an article this past week on it in Police and Security News magazine, and your listeners can go to the Police and Security News website and download the whole thing. It's free. The magazine's free. But God's eye fallacy says that when you look at video footage, you'll come away with a different perspective than when John Simpson looks at it or when I look at it. We all see different things. And this is especially true. They've done research where they've shown potential jurors video footage, and they've made a suggestion. The guy had a knife in his hand. Well, he really didn't.
Mm.
But when the video was watched by the jurors, they often said, yeah, he had something in his hand. There's a lot of potential bias when we watch things. We sometimes are looking for specific things and maybe find them when they're really not there. And it's called the God's eye fallacy because you're looking down, like on the earth, or you're looking down on the scene. And actually, this term kind of surfaced in the late 1800s when they were taking photographs, and they'd photograph a crime scene from the top, thinking that captured everything. And that's where the term God's eye fallacy came from. But it can be very misleading. And it's something that attorneys have to deal with, judges have to deal with, everybody has to deal with it when they're showing video to a group of jurors or to officers. And then the question is, should the officer watch the video before the report's written or after the report's written?
Yeah, that comes up here.
And that's a real debate. Officers who watch it before they write the report might include things that they didn't even see. If they watch it afterwards and they write a supplemental report or they go to correct things and the plaintiff jumps on them and says, well, you wrote a supplemental. How come you didn't have that in your first report? And we have an agency here in the country, here in the U.S., that I kind of like their approach. The first report their officers write is called a perception report. It's what I perceived. And that's really what it is. I mean, we perceive things. So they call their first incident report a perception report, and you write the perception report, then you watch the video, and then you write a video supplemental report. And that kind of captures everything. And I particularly like that approach. Some officers may not, because, we're all human and we all look for the easy button. Just make it easy. The video captured it, it wrote the report. But you go to cities like Seattle, some cities here in the United States, video drafted police reports aren't allowed. And in one case in Seattle, the video report, the actual first draft video report that came out, had officers mentioned who weren't even there.
Oh, really?
So somewhere in that video memory, it went back and grabbed some stuff from another call, I guess. I don't know. But the district attorney said we can't rely on them.
Yeah, and we do something similar to kind of what you're talking about, like that first draft. So members aren't allowed to watch their video. They have to come in, write their report. If there's like a use of force, say, I'll just use that as an example. There's a use of force. You have to come in, write your report and your notes, send it off. Once that stuff gets approved, then the member can watch their individual video. And I'm just saying this like very basic. There's a bit more to it, but so they can watch it later after certain things are approved. If you notice something on the video that you're like, oh, you know what? Now I see this. I want to make mention of it. Then you can do a supplemental report and put in, hey, upon further review of body-worn video, I saw this, didn't see this, whatever. I heard these things, and now I want to add on to it. And kind of going back to what you were talking about, like the different drafts of reports. We have that where the first draft goes in. If it gets reworked, like your supervisor reworks it to you, still keeps that draft. And then that goes into disclosure.
Right.
So the defense can see, like, you drafted this whole thing. Oh, but now you changed this sentence. Why'd you change that now? And so we already have all that kind of stuff. So it's kind of interesting just seeing the overlap between the US and Canada and some of the similarities and differences.
Yeah, and I think the law lags science and technology. I think that's true universally. It doesn't matter what country you're in. And we're not going to really know about some of the answers to these issues until the court weighs in. And that may be 4 or 5 years out. Now, we just had an incident on the West Coast in the Ninth Circuit where an expert witness used AI to write his report. And in the writing of that report, he never checked any of the references.
Boy.
So long story short, he testified about his report in a deposition, and defense counsel, it was a civil matter, so defense counsel went to the federal court and said, look, we want every prompt and everything that he did to get this final report. Plaintiff argued that's attorney work product. You're not entitled to it. Defense counsel said, oh no, we're entitled to it. Under our Rule 702, he relied on it. And if he relied on it, we're entitled to see it. And the federal magistrate said, that's correct. You've got to turn it all over. Turn over everything. Turn over every prompt, every draft, every answer, everything he got to write that final report. So It's really cutting edge. And as my friend says, the worst artificial intelligence you'll ever use is what you're using now.
Yeah.
Because this afternoon it'll be better.
Yeah.
Yeah. Because it's like I have to tell you, when I and I advise the listeners, just keep watching this channel, because Dr. Peters is doing, I have no doubt, will be offering another artificial intelligence prompting course. I took it myself. That's one of the driving forces for why I had Nate invite him back. And I got to tell you, as a long time trainer, I initially had that sinking feeling when the instructor uploaded a a training handbook. It was a training handbook or a lesson plan, and just prompted the AI, "Hey, write me a 10-question written test in this format and provide an answer key." And I'm sitting there. This was a remote class, and I'm sitting here watching this AI write a written test. And then it was like, but it was one of these deals where, long before AI was a twinkle in anybody's eye, you still have the overriding principle that authority can be delegated, but responsibility can't. So if hey, Sergeant Romas, we need you to when you're putting together this training course, we got to have a written test for it. Yeah, okay, sure. And you turn to a fellow Mountie and you tell him, "Hey, give me a 10-question written test with an answer key." It's like, well, you've delegated that task to him, but the overall responsibility is still yours. So
Yeah.
so all this is just a sped up version of what we've been doing for decades, where you tell somebody to do something, you don't just automatically take that and go, "Hey, thanks a lot," put your name on it, and submit it up the chain of command. So you still have to be able to review. You have to be smart enough to review whatever the AI comes up with, because we're still having the problem with AI hallucinations and
Hmm.
made up references and stuff like that.
Maybe I'll jump on that because just like you were saying there earlier, Dr. Peters, like the law enforcement piece might be like a very small sliver of the entire pie. And so
Right.
people aren't necessarily focused on it. But when you, like what John's saying, and kind of combined with like where law enforcement comes into people's lives, and it's usually like life or death matters. Uh, it might be a small sliver of the pie, but the impact of it, we bring in another circle, it's going to be huge. So,
Correct.
it's like, are we giving it its due? Are we paying attention? As you kind of said before, like even legislation doesn't keep up with the technology. I feel, and I'm more pessimistic on all this AI stuff. I don't think humans are going to be able to keep up with this, or at least, the majority of people. I think it's going to be a very difficult time. It's going to revolutionize a lot of things and make things better in a lot of ways. But I think a lot of the bad that can come from it, we're already seeing it. And on the law enforcement side, like, do we have any answers? I haven't seen them. They might be out there. I haven't seen them.
Well, I think, Nathan, you've raised a lot of good points there. So, if I might, let me back up just a moment. When John talked about a prompt is really the instruction you're giving AI to do something. That's really all it is. When you go into a restaurant and you're handed a menu and you say, "I want a hamburger," that's your prompt to the waiter or the wait person. "I want a hamburger." And that person comes back with a hamburger. nothing else. And you go, wait a minute. There's no bun, there's no tomato, there's no onion, there's nothing. You just brought me a hamburger. Well, that's what you asked for.
Yeah, very specifically.
And that's how the machine interprets things. So
Yep.
the prompt could be part of the initial problem. The second part is we've now got AI that's doing 80 billion calculations per second. And just like the brain, the AI is built using what we call neurons. And everything in AI is based on probability and statistics. That's why you get mistakes. When you and I are working the street and our partner makes a mistake or a secretary makes a mistake, we don't say our partner or secretary is hallucinating. We might think it, but we wouldn't say it. But we use that term in artificial intelligence, and I tell people, just say it made a mistake. Don't get into the hallucination stuff. It just made a mistake. That's why across every AI platform and across every AI program, it says you have to have a human in the loop. The human in the loop does the checking and the verification to make sure that things are right. But here's what's really happening. And to your point, yes, there are deep fakes. We have bad actors who are taking pictures of elementary school kids and putting them on nude bodies and sending them around. We have scams that are taking place on AI that we never had before. But the other side of that coin is that if people aren't up to AI right now, if they don't understand prompting, they're really behind because that train left the station. What's happening today is called AI agentics, where agents are being built. In fact, agents are now orchestrating. They're called orchestration agents. They're managing other agents. So it's taking the human even farther away from the day-to-day activities.
Wow.
But we're starting to use a lot of this stuff in law enforcement. Flying drones over a crime scene or an accident. Maybe to give feedback for triage or just to give feedback of where this actually happened. So officers can respond. We're using robotic dogs to go into dangerous situations instead of putting humans there. So AI is here, and we have to embrace it. But the mistake is you can't totally rely on it. We have to manage it. We give demonstrations in class all the time. You have an internal affairs report that comes in, or complaint. You take that complaint and you look at what the citizen said the officer did. You can take that information, plug it into AI, and say, using our policy manual, identify every potential violation based on this complaint. And it'll do it in 5 seconds.
Yeah.
It'll give you the page number and section number. Now, does AI know that's true? Well, it knows the document's okay, but it can't interpret. It can't go out and do the investigation. That's where you've got to have boots on the ground. You've got to have people thinking about this. But one of the things that we have recently completed here at the Institute is a lesson plan generator, where all you need to do is put in the title and the length. Do you want it an hour? Do you want it 40 minutes? However long. It'll write your whole lesson plan. It'll come up with all the test questions with the answers, as John described, and it'll do that in maybe 2 minutes' time.
Yeah.
Now, that saves probably 100 hours of going out and finding the material, reading the material, synthesizing it, and developing that lesson plan. But you still have to know enough about the subject that when you read through it, you know where it's correct or maybe where there's an error.
Yeah.
So it's a real asset. It's a real help.
Yeah, no, I agree. And you know what? I foresee people are still going to be involved in this, and you still need the human element. This would be a good discussion for another time because especially once AI keeps building up here. But maybe I'll kind of leave it off with this is I see, the criminal element. If we get into that, they don't have to play by any rules, right? They don't have any policy procedure. They just go
Right.
out, throw things into the wind, and if something sticks, hey, we won, right? We get all the money or whatever it is they're trying to get. Whereas with police, we're like these little baby steps, one at a time. The other part of it, and maybe it's a bigger concept I have to think a bit on, is the AI that criminals use. I feel like they're in like the hybrid warfare stages, right? It like crosses over into so many realms, a lot of which aren't necessarily physical. And I think people can't really grasp that. Whereas, like you're saying, for policing, we put AI in a drone, we put it in the dog, we send it in. So we're doing things at like a very local level as police, but are we as law enforcement able to really see like these big pictures and take on those things that cross borders? Because that's where a lot of the money is. That's where the millions are flowing and what supports everything from organized crime to terrorism. So, but discussion for another time because we're just at the end of the time here. So, but I really do want to say like thank you for being on here and talking about this. It's critically important information. So thank you for what you do. Just as we do kind of wrap up, I always kind of end on where can people find you? Where can they follow your work? So what are the best places for that?
Probably the best place to go is our website, which is www.I, P as in Paul, I, C as in Charles, D as in David.com. You can find all our programs there. We have a library there as well. Our upcoming programs on AI. We have an AI symposium being planned for early next year. And some of our speakers in that program are going to address the international issues of human trafficking and other things. So the only thing I would say to the reader is don't be afraid of it.
Mm-hmm.
Fear is usually based on what you don't understand. At least put your foot in the water and get to understand a little bit. And programs like what you're doing, Nathan, are so important because it's helping to educate people and maybe take part of the fear away, or at least get them to try something. And if you try something and it just doesn't work as planned, go try it again. None of us picked up a revolver and shot a perfect score the first time we qualified.
Yeah.
I mean, you've got to practice it. So what you're doing, I think, is very important to the law enforcement profession. I thank you for doing that. You guys are doing a great job, and keep it up. And you're exploring subjects that a lot of people may not have known much about, or may not have known anything about, or maybe have misinformation about. And you're trying to set that record straight. So you're doing a great job.
Oh, I appreciate it. John, you got any final word?
Yeah, nice of you to say so.
Yeah. Hey, I want to say thanks again, Dr. Peters, for educating us. We'll have to get you back on. And as always, John, thanks for co-hosting. And we'll all chat real soon. Hang on the line. We'll just chat right after.
All right. Very good. Thank you.
Awesome.
Hey, everyone. Thanks for listening in and following along with the discussions. Be sure to click the follow or subscribe button on your respective listening platform. Also, check out the Quiet Professional on X and Instagram under TQP780. And most importantly, please share where you can. Everyone has a part to play in getting these education and information pieces out there, so pass it along. Thanks again.